Now, I think I was here 2 weeks ago in the night show, Primetime 9, and we were discussing how the impeachment is going to unfold. As at that time, National Assembly had already finished with the impeachment motion, which set the space for the trial at the Senate. And our conversation then was worst way out for the Deputy President, His Excellency Gachagua, but importantly, what will unfold. And in that segment, if your viewers were following keenly, I said this battle will be two-pronged. One, it will be on the legislative side, which is National Assembly and the Senate. But that will be only one side of the story. The second side of the story that will drag on for quite some time, and it will be more or less like scorched-earth policy, will be the judicial fight. The reason is, at that time, my prediction was Rigathi had two narrow choices. Make a decision just after National Assembly had finished their motion and forwarded the same to Senate, resign, so that it brings a closure. And that would have come from a self-preservation mode in terms of he can't be and he can't remain politically active because impeachment has a finality. Yes. But number two, I said, fight it out in the Senate, but remember, that means if the Senate succeeds in impeaching him, that's a done deal. Only salvation remains judiciary, and that's where they are. Now, let's look at their second level, what they are doing. Their approach has been create as many legal fights as possible. Approach several forums of the court to address the issue of impeachment. They are attacking the process, they are attacking the outcome, and they're equally attacking the impartiality of the judiciary. So three things they are attacking at the same time. So that if you saw their filings in the first instance was basically in two different courts, at the High Court, was to get orders that temporarily suspended the resolution of the collective house, both National Assembly and the Senate. And they succeeded to get, in fact, two interim orders were issued separately. That's number one. Number two, after they had interim orders that meant, and the interim orders at first instance, people assumed that they were out of time. But if you look at the wording of the orders in the two courts, one kind of suspended the execution of the resolution of Senate because gazettement had been done. But secondly, it equally went, the second interim order went further to even stop the swearing in of the Deputy President designate or appointee, Professor Kithure Kindiki. So in that, they were secure for now. Then now they moved into their second space of now attacking the impartiality of the bench, because that would mean once you had several cases, it was easier now for the judiciary to consolidate under one bench. And that falls under the ambit of the Chief Justice to nominate a panel of judges. And if you look at the 3 or 4, 5 applications they had done before, each of the individual judges at the High Court had already recommended and had written to the Chief Justice that this matter is of serious, huge public interest and can only be handled by a 3-judge bench. And that's why it was constituted under the 3-judge bench. That's when now they moved into their second level of fight, which was to accuse the impartiality of the bench. But even before accusing the impartiality, they even attacked the process of the nomination, because it is the Chief Justice who nominates. But in this case, in the absence of the Chief Justice, you have the Deputy Chief Justice. So they were attacking the process, whether it was valid for the Deputy Chief Justice, Philomena Mwilu, to nominate. And when that failed, then they moved towards impartiality. And if you look yesterday and last week, they were saying the judges are biased. And that's why now they were making an application for recusal. Again, that one was defeated. Now they have gone further. So they're just shifting gears. Now their next step is now to attack the process, which is the impeachment proceedings. And that has not come because that is
at the Houses of Parliament.
Both. Yes. So they have not even got to that yet. Why? Because that is a substantive application that we'd expect need to be had. So we haven't even started hearing the substantive aspects of these matters in court. What we are now seeing, yesterday, they were focusing on the nomination of Kithure Kindiki. So they will seek to prosecute nomination of Professor Kithure Kindiki, so that to put court in a place where it has to rule whether he was validly nominated. And they raise serious issues, like, for example, saying he's not been a member of the UDA, the requirement is 3 months in advance. Number two, he did not resign from cabinet. So we are going to put a test to this law. You remember this law when it comes to elections. Most of us, before you could vie for an elective seat, it was a choice of resigning 6 months in advance. But this may be a bit dicey. I remember when I was a speaker of Nandi County and I sought to vie for the governorship, then formerly deputy governorship for Nandi, that question for me would have come. But now I was already still serving. So, and I remember courts have already made rulings about such a case. So they are inviting the court to make a ruling on that. But importantly, once this is being determined, they'll now go for the process, which in this case, they will now seek to bring substantively the issues of public participation and whether indeed the impeachment proceedings were valid. So in a nutshell, if you see, we are just warming up in the judicial fight.
So Wakili, if I hear you right, is that this thing is nowhere near the end?
You cannot, now judiciary